This is remedies, and we're on section 6. We've got a few cases to do talk about with respect to injunctions and the process of injunctive relief. We also have Rule 12 on the agenda to talk a little bit about 12B, motions to dismiss and the like. So if you want to look at your rule book, if you have one, and think a little bit about it, what Rule 12 talks about is how defenses are presented, and those are going to come relatively early in the process in response to the complaint that's filed. What Rule 12 tells you is that within 21 days of service, the defendant has to do something with respect to that complaint. And the choices, as you know, are to either file an answer the most common responses would be to file an answer or to file a motion to dismiss. Rule 12 also makes reference to what's called the motion for judgment on the pleadings as well. We'll talk a little bit about that because that's not as well known. And in the event you don't do one of those two things, it means you do nothing. And if you do nothing, a default judgment will issue and you will ultimately lose the case because you failed to properly contest it. So 21 days after having been served, you've got to do something. And the same thing happens, by the way, as the rule makes reference to under B here, under small a and then B, where it talks about you have to serve an answer to a counterclaim or a cross-claim within 21 days as well. Sometimes I've been contacted by lawyers who forget it's not just the complaint that has to be responded to, but if we've got multiple parties in the case and there are either a counterclaim or there are cross-claims asserted between those parties, that also requires some form of response, and in the event you do not, you will be defaulted on that pleading as well. So you've got to be cognizant of that. It's not just, you don't just get it and then leave it in the file. You've got to do something with it at that point. As a general matter, if you file a motion to dismiss, it tolls the time for filing an answer on the case. And that becomes important sometimes because it may take a while to actually either make financial arrangements with your client, to be able to have your client gather the essential information so that you can satisfy your Rule 11 inquiry. And so there will be times where you will either need an extension of the time to file some type of response, or in the event that that's not granted either by the other side or by the court, and you got to make sure you do one of those things. Sometimes you'll file an motion to dismiss if there's any reason that legitimately you can file such a motion. And if you look at your 12B motions, we talk about lack of subject matter jurisdiction, personal improper venue, insufficiency of process, service of process, failure to state a claim upon which relief could be granted, or failure to properly join a party. What happens in a lot of complaints is that there are multiple counts that are established in the complaint. And we've seen already different cases where it's a breach of contract, it's torts, it's 93A, it's a whole bunch of different issues. Filing a motion to dismiss sometimes doesn't necessarily deal with the entire complaint, but there may be specific counts within the complaint that you feel are less meritorious than others. And the fact is that we will use a motion to dismiss to try and limit some of the causes of action against our client. And not only is it not improper, I think it is proper to try and reduce the number of potential theories of liability that you may be your client may be subjected to. And again, I also think early on especially, it's nice to win a few battles and start to let the plaintiff know, assuming you're defending it, let the plaintiff know that their complaint isn't as meritorious and likely to succeed as they might. So oftentimes you will find some of the counts within a complaint as less supported than others, and there may be reasons why some of those counts should be dismissed, and that means that you really ought to look at it that way. I think we tend to think in the law school, when we talk about dismissing the complaint, because that's the way we say it, you think of, well, the whole thing or nothing. And the fact is, in a multiple count complaint, there may be, you may have the ability to get rid of some of those counts. And then what that means also is not only have you reduced the theories of liability that your client is exposed to, but you've also likely limited some of the discovery that's now possible, because if those counts are gone, the information that they would have sought under those counts would have likely been broader than what you may now be, your client may now be exposed to. So that becomes important. Also becomes important because from the standpoint of defending the case, defendants have a tendency to want to slow the whole case down, with the theory being that every day the dollar stands in my pocket is a victory, as opposed to giving it to the other side. And a very, very, very common tactic of people who defend cases is to simply drag it out as long as possible, with the expectation that sooner or later the other side will cave because they have no money or resources or time left to devote to the case. And it's, in fact, it becomes a real problem sometimes from plaintiff's perspective to be able to hold out indefinitely when the defendant just keeps trying to postpone and slow things down. You know, I used to do this stuff when I was, even when I was in college. I worked as a law clerk paralegal for a law firm, and there was a lawyer there who said, from a plaintiff's perspective, what you want to do is put blinders on and focus on trial, trial, trial. Just as soon as you can, get to that deadline, get to trial, try the case, and who knows what's going to happen in trial. But frankly, I think the insight he gave me was absolutely correct. You know, you need to think about that. No matter what the distractions are, as a plaintiff's lawyer, you focus on the target date of trial, and everything else really is irrelevant with respect to that. So you ask me for an extension to file an answer, I'll give you that probably, as long as it doesn't delay the ultimate goal line that I need to get to. You want to extend discovery, I might even agree to that, as long as you're not going to use that as a lever to try and extend the ultimate deadline for trial. Case is settled. As much as we can preach early resolution of cases and ADR and all the rest of it, case is settled because someone feels that they're going to the gallows in the morning. And the fact is that that sharpens their attention to try and resolve it, knowing that there is a deadline. I've given you guys various deadlines over time to file things, and invariably the bulk of them still come in within the last day or two, despite having lots of time to do things. Well, most lawyers function like that. They function on deadlines, and if you have a trial date set, you want to hold that. Conversely, if you're defending, taking your time, making sure you get it right, making the plaintiff dot his I's and cross his T's. If one of those things means filing a motion to dismiss under Rule 12, that in fact is what you do. Again, you don't care necessarily how you win. If you can win early by throwing the whole complaint out of the out of court, then you've had a successful case. There's a couple of other things to think about with respect to this. With respect to motions under Rule 12 that are viable. It says motion for judgment under the pleadings under, no, it's not 7, it's just a separate C. After the pleadings are closed, but early enough not to delay a trial, a party may move for judgment on the pleadings. What that means is after the complaint is filed and the answer is filed. That's when technically the pleadings are closed, because there really are no other pleadings at that point that are generally that are filed. A party could move for judgment on the pleadings, and all that means simply is looking at the answer in the complaint. There's no reason why we should look any further. This case is over. So either the defendant has agreed to everything the plaintiff said, or the plaintiff's complaint and the defendant's answer show that there is nothing outside those pleadings that anyone needs to look at in order to determine the judgment. It's somewhat rare, but it does happen, and that's found under this rule as well. Under 12b-6, Motion for failure to state a cause of action upon which relief can be granted. Either factually or legally, the complaint's insufficient. If affidavits are filed, if the court looks to those affidavits or other matters outside the face of the complaint, then they are treating that as one of summary judgment, and the court can award summary judgment on a motion to dismiss like that. What that means is you've got to be careful that you don't turn the motion to dismiss as well into a motion for summary judgment. It does talk about the court has to give parties a reasonable opportunity to present the material pertinent to the motion, but the fact is there will be some defendants who come right out of the box and file a motion to dismiss under Rule 12 or in the alternative for summary judgment. And if you're not prepared to oppose that motion with specific information and evidence, your days may be over already. Yep?
When you say a failure to state a claim for which relief can be granted, I understand all the other 12B motions,
yep,
but that one...
That's the one that's used most often, actually.
Yeah,
yep.
Yeah. What exactly are they saying? You're saying that the facts don't substantiate or support the allegation in the complaint, or what's an example of a claim that relief can't be granted?
That's a stupid question.
Yes.
No, that's a stupid. I say that's a stupid question. You say, "Oh, my feelings are so hurt. I'm going to sue for emotional distress, intentional infliction of emotional distress." Now, if you are a law student, you should be used to having someone say to you, "That's a stupid question." You really shouldn't, but we're going to use it for the illustration. Okay. But at any rate, so he sues because he's been so badly injured as a result of that cruel remark. Cruel remarks are part of life, right? We do not and are not able to recover for every slight said to us over the course of our lifetime, right? So, if he sues me for that, I believe I am going to move for a 12B6, saying, yeah, okay, I said it. It doesn't even matter whether I said it or not, because what I've said doesn't amount to a violation of law. It's that simple, right? You've failed to state a cause of action upon which relief can be granted. Now, that's probably partly legally, because that doesn't arise to the level of emotional distress, I don't think.
So the facts don't support the
facts or law. Facts or law. So, and that's why it could be one or the other, and sometimes a combination of both. And that's precisely what that means. Okay, there's a wrong done to you. The law doesn't recognize it as a wrong, or it's not your wrong. Maybe it's your employer's. Either factually or legally, the claim doesn't warrant any recovery. Okay, and we use it a lot. Sometimes, for instance, I had this other discrimination claim and handicap discrimination, harassment, a whole bunch of things, and some of what they were alleging that took place, and they took place. They said, well, in the workplace, that doesn't rise to a violation of the law of which you're entitled to relief. Meaning, at least in part, some of those claims should be covered by workers' comp if they happened at all. You don't have a claim under the law that you're entitled to recover here. It also raises the issue of lack of subject matter jurisdiction for the counts. But 12B6 happens a lot when you look at the violations. And if you think about it, you know, the emotional distress is one, but there are other things where they're, okay, you know, we thought we had an agreement, but for whatever reason, you guys would know better than I, that agreement had to be put in writing. And now you want to recover for it, but you don't have a writing to support it. Well, then you have failed to state a cause of action upon which relief can be granted if that's one of the contracts that's required to be reduced to writing, and it was never reduced to writing. Okay? And then that's what we see. We actually use 12B6 a lot. And it's usually on, not necessarily all the counts, but there are usually some counts that they don't fall neatly into torts or contracts or this or that. And you look at them and say, well, what law supports your right to recover under those circumstances? And it may not be one. And sometimes it may not be factual. Factually, it's just not there. You have duty, you have breach, you have harm, you don't have causation, out you go, right? Because you failed to state a cause of action upon which relief can be granted. That's 12B6. And 12B6 gets used a lot, okay? Questions on that, on the motion to dismiss? Motion for a more definite statement. and we looked at this in Civ Pro. Motion for a more definite statement is not supposed to be used as a means of obtaining discovery, in essence. A motion for a more definite statement should be only granted when the complaint is so insufficient that you really don't know what they're saying. And under our notice pleading system, that should be incredibly rare. Because frankly, if I thought it was that deficient, I'd move for a motion to dismiss for 12b-6, failure to state a cause of action upon which relief is granted, than to give you a chance to correct it. Because why would I want to give you a chance to correct it if I think I could knock you out of the park? But maybe I'll do both. Motion to dismiss for failure to state a cause of action upon which relief can be granted, or the alternative for a more definite statement. And I've seen that combination as well, so that it gives the judge an alternative. The problem is the pleading standpoint, from your obligation under notice pleading standpoint, is so low. All you got to do is put me on notice as to what the complaint is about. If you have a complaint, you should be able to, in brief compass, state it to withstand such a motion.
What would compel you to put in a motion to state the alternative anyway? I mean, don't you? In other words, you want to make. You have a motion to dismiss.
Yep.
Okay. Or in the alternative, a motion for a more definite statement.
Yep.
Why would you want to even give the judge that option? I mean, if it's a motion to dismiss, you just want to get it out of the court to begin with, as opposed to giving the other side an opening to refile.
Well, sometimes, frankly, these are used to delay and slow things down. So you know the likelihood of actually getting your motion to dismiss is low, but maybe I'll try to cloud things up a little bit. You know, the old adage, if you can't convince them, confuse them. And I'm not suggesting that you should do anything improper or unethical, and I'm not suggesting these things are, but I also, I am recognizing the reality of the situation, that as a defendant, even those that we see as guilty or responsible, they're entitled to a vigorous defense under our system, right? You're the advocate, and they're entitled to a vigorous defense. And the fact is, if I can use the process, if it's advanced in good faith, to assist them with what the outcome they would like to see, that is our job, right? And so if I can, with a straight face, make the argument that one of those motions should be, even though I think the motion to dismiss is a stretch, and the motion for a more definite statement maybe is more likely, then you make the argument, because that's your obligation. And his obligation is to represent his client. You know what I mean? I don't, and I'm not trying to, and I know sometimes it may seem like this, I'm not trying to preach to you that you have to be, super moral in representing clients. I think you need to find a balance between your activities and what we are permitted to do under the Code of Ethics, and what we're not just permitted but required to do. Recognizing that at times the code allows us to do a lot of things that are going to mean some people suffer lousy consequences as a result of what we do. But that's the nature of it. I mean, I advance motions and arguments and cases that that I think could lose, right? Because you've been wrong before. I hope we should win. I think we've got a solid chance to. But the likelihood is, if things go the way I see them up here, we should lose. Conversely, there are cases where you take that you expect to lose and should lose, but you don't. So we don't get the final call on that, as we've talked from time to time. So I'll advance these motions, and I'll be mad when I'm the plaintiff, and oftentimes I am, and they're advancing what I see as motions that 1 in 10, 1 in 20 have a chance of success. But I've also seen ones 1 in 10, 1 in 20 where I've said, oh, they got that little chance of success, and then they knock a count or two out. So our assessment, you've got to do consistent with your rules and your obligations to the client, right?
I was going to ask you, you have to act in good faith, though, so you can't just throw out a 12b-6 motion unless you can cite like a lack of an element of the tort or whatever, right? I mean,
agreed, or lack of
factually. I mean, what's involved in it?
No. Your assessment is correct. But you would be surprised, or may not be surprised, at how incredibly sloppy some lawyers are. I'd almost guarantee you, most of you, and if you've done any of it here, you all go to the form books and just copy the complaint that's in there. And invariably, even the complaints in the form book downstairs are full of conclusions of law as opposed to facts that support what the conclusion of law should be. And the rule is clear on that, is you are supposed to plead the facts that give rise to a conclusion of law. But go find a complaint downstairs for an auto accident case that doesn't say the defendant was negligent. Well, that's a conclusion of law. Without the facts that support it, I'm going to try and dismiss it if I'm defending, because I can. And I also think it is improper. Most judges may not agree with me, but the law is pretty clear in that regard. They would just want to proceed faster to the next step. What are the facts? And that's what goes in a complaint. And so I think that's part of it too, is that there are a lot of lawyers forget what they learned in law school and then just sort of get into a routine, and when they need that next complaint about the auto accident or the doctor's malpractice, they get the last one and cut and paste new stuff into it, and since it worked the last time, it should be right. You know, one could have a secretary practice law if that's the way you intend to do it, and a lot of people do it. And that's all I'm saying. When you look at every complaint, every answer, you should look at it to make sure you're comfortable that it comports with the requirements. And 12B allows you to be able to make a check on that and potentially get rid of cases before they become huge, expensive pieces of litigation. And that's the other part of it, right? The motion to dismiss, if you don't file it or we move to an answer, then the next step is we're going right away virtually to discovery. Cha-ching, 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 cha-ching. So if I can knock it out here, 1 in 10, 1 in 20, you step to the plate and you try and hit it, right? Because that's going to save your clients tens of thousands of dollars if realistically you have any chance of that. It also may give you some additional time to make sure you file the appropriate answer, counterclaims, and whatever else you have. So that's motion for judgment on the pleadings. Motion to strike, which we don't see a lot of, but I've used over time. F, the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. And over time, you'd be surprised, but you do see both impertinent and scandalous matters within the complaint and the answer. And the problem with that is those are public documents that anyone else then can look at. Now, striking it doesn't necessarily mean it's gone and someone can't find it. But there will be times when information is within that really is not there or necessary in order to satisfy the law. It's there to bring embarrassment to a party, because some people will use litigation not just to achieve the just result, but will use it to punish the other side, and will use the court process itself to bring embarrassment to them as well, in hopes that it might settle. So that happens as well. Anything else on that? Yep.
It says the court may order stricken any pleading, the insufficient defense part of that.
Yep.
It makes it seem like a motion to dismiss. Is it? But I understand what you're saying about the scandalous matter.
Well, where are you reading from, John?
Motion to strike.
Yep.
The last sentence. The court may order stricken from any pleading any insufficient defense or any redundant. And then when it says,
right.
I understand redundant, immaterial, impertinent, or scandalous.
Insufficient defense?
Yeah.
Well, suppose it's a negligence case and you plead statute of frauds, right? That's just insufficient. Actually, it's irrelevant to that type of claim as well. And so insufficient just means simply, it may well mean it's not applicable to the count that's alleged, or you don't have sufficient facts that would justify that defense. Again, now that's very rare that you see a defense struck as insufficient, but again, I have seen that on occasion in 25 years practice. And again, now we're really, the problem with, the further down the list we get, we're getting into real, what I might approach is sort of what I'd call sort of a scorched earth approach to the case, is that we're going to fight about every little thing on every time from here till this case gets tried 2 years later. I mean, truly, if you think about John's question, if it's an insufficient defense, why would you bother even striking it? Because at the end of the day, under the law, it's not going to work for them anyway. But theoretically, you could move to strike it as insufficient. So, again, you don't see that often. I've probably seen it 1 or 2 times, but I don't see it as because, by the way, and this goes more. Well, actually, it goes more with the last part of this. Affirmative defenses, right? Your obligation as the person filing the answer at the end of the day is to file any affirmative defenses with your answer or your response, which is your response to the complaint. There are some attorneys that will file a laundry list of affirmative defenses. But seriously, I've seen as many as 25. Just pure BS. But they've got sort of their package, and we throw them all in the hopes that if I need them later on, they're there, which is not unreasonable, because as you know, if you fail to plead an affirmative defense, that's on you later on, because that constitutes a waiver. So there are some attorneys that will file sort of this blanket, comprehensive, omnibus list of affirmative defenses. Now, arguably, that's not consistent with Rule 11, because you're not supposed to be pleading matters that are not in good faith and not based on existing law or good faith belief in reversal of existing law and apply to the facts. And so we could argue that that violates Rule 11. The problem with that type of list is I think some lawyers do that to hide 1 or 2 that might be really good in there. And so you really got to scrutinize the list carefully to see if what they're really trying to do is play hide the ball, and that there's a couple in there that they intend to rely on that may be applicable. And if they obviously just pled those 2, your focus would be directly on that and try to figure out what the problem is. They plead 25 and you say, oh, it's all BS. It probably isn't. There's probably a nugget in there somewhere that you've got to figure out how this could hurt you either shortly or more likely later on down the line when they decide to play the card when the statute of limitations or something else has run, so you can't re-plead. And so you've got to pay attention to it either way. I don't think it isn't consistent with Rule 11, but your affirmative defenses have to be pled as well. And they're going to need to be pled in your answer. Also, if you choose not to file a motion to dismiss for some of these various reasons, and if you file for any, generally they have to be all done at the same time. But if you choose not to file those as a motion to dismiss, if you look at Rule 12H, you can also file them as affirmative defenses as part of your answer as well. So there are ways to plead some of those matters as part of your assertion of affirmative defenses as well. But Rule 12, more often than not, really in the practical world, you're dealing with motions to dismiss, but there are, as you see, a couple of other motions that can be filed consistent with that. Questions on that? In civil practice, we tend to use Rule 12 a lot. Again, those of you that have me before or have done the PowerPoint presentation know I see it as the first of our 3 testing motions. It tests the complaint to see if there are procedural or substantive deficiencies involved. Second of the 3 testing motions is motion for a judgment as a matter of law under 50. And the third of our motions is next week's class, which is Rule 56 with respect to summary judgment and the like. Questions? So let's look at Franks versus GMC Truck Center, a 1990 case seeking injunctive relief. And I've got some questions to ask you about here. And it talks about the bond. Franks files suit against General Motors Corporation, right? He filed suit in the Superior Court of New Jersey, and in addition to money damages, sought injunctive relief, preventing GM from discontinuing its supply of heavy-duty trucks. GM removed the action to U.S. District Court for the District of New Jersey, and the application for injunction was heard on January 5th, 1988. How does an action get removed from state court to federal court? Well, is that what happened here? Was this removed on the basis of diversity?
Could be subject matter to it.
What's that mean?
That means that there's a question of federal law.
Okay, so a case can get removed from state court to federal court if what? If there's a question of subject matter jurisdiction, or what do you got?
Federal question?
Federal question. Anything else?
Diversity.
Diversity. Well, that diversity would be part of subject matter jurisdiction. So what else? Because you're going to file some complaints, and all of a sudden you're going to find they're in federal court. My question is, now what? Oh, you're going to be defending cases and say, maybe I should go to federal court. Never been there before. Beautiful building around here, and it is. It's gorgeous.
Do you have to be licensed to practice in federal court?
Yep, you do, as a matter of fact. Which is relatively straightforward if you want to be admitted to the First Circuit in Mass. Once you're admitted to the Massachusetts State Court, you can apply for admission to the Federal District Court as well as the Federal Court of Appeals for the First Circuit. You've got to apply, but there's no test. And by the way, something seems like you better do.
Well, that's what I was just going to say. You just lost the case to
Yeah, you're right.
a lawyer if you
So
don't.
you're going to have to call me and say, Mike, I got a really good
Yeah.
case, but I can't do it anymore. Say, well, maybe we can help each other out here. You're really right. So it is something you want to do. That's a good point, Freddie. By the way, you also, when you do now, it's something you want to do at the outset because there's then a process you're going to need to be trained. It's online, but you're going to need to be trained to be able to do electronic filings, because in federal court, that's the only method of how we do things anymore, is file things electronically. You're going to have an account set up so you can access the PACER system. It's really, all of it's relatively minor compared to, say, taking a UCC exam. But with the crush of time, sometimes with litigation, you got to recognize that if you haven't done it, now I got a problem because I can't even file a paper until I'm admitted to the court, until I have these privileges. So I want to know, and I know some of you know, how does an action get removed from state court to federal court? On what basis can it be?
If the original action could have initially been brought into a federal court to begin with, and the rules of diversity jurisdiction apply.
No, you got the last part a little messed up. If the action could have otherwise been brought in federal court in the first place,
Is it removal?
unless,
Is it removal jurisdiction?
yeah, that's what we're talking about, removal jurisdiction.
Right.
Or if there's a federal rule of civil
Now you're messing up the area with it. So what's the unless? An action can be removed from state court to federal court if the action could have otherwise been brought there in the first place. So that means federal question, right?
Is there a
Question
choice-
of a constitutional issue, a diversity case. But,
choice of law?
no, now I do it, Alina. But, if removal is predicated on diversity jurisdiction, the defendant cannot be from that forum. Sounds familiar, Laura, right? Right? The defendant can't be from the forum. So, where are you from? You're from here too, though, right? Who's from New Hampshire? So, Laura's from New Hampshire, Mike's from Mass. Mike sues Laura in Massachusetts State Court for $8 billion. Can Laura remove that action from state court to federal court? Yes, because the action could have otherwise been brought there in the first place, and since it's predicated on diversity jurisdiction, no plaintiff matching a defendant's state and a claim reasonably likely to exceed $75,000, Laura has the right to remove it from state court to federal court because she's not from Massachusetts. Conversely, Laura sues Mike in Essex Superior Court for $8 billion. Can Mike remove that action from state court to federal court? The answer is no, because Mike is from the state where that case has been filed and removal is predicated on diversity jurisdiction. If removal is predicated on a federal question, then we can remove it even if we're from that forum. So why do you think Franks sued GM in state court to begin with?
It would be more favorably towards
Sure,
it.
right? Don't you think a New Jersey state court would look more favorably on the local business
Which they
who was
did.
suing at that time, and I guess now again, a large out-of-state national corporation who was deciding that they don't want to do business with them anymore. So they filed in state court. But this is why this becomes important to understand removal jurisdiction, right? Because that has to be part of your thinking now. Okay, I'm going to have it in Essex Superior Court. Well, I got to recognize, you got to recognize what are the defendants' likely responses under those circumstances. How are they intending to delay and make my life more difficult? You know, frankly, I like federal court. There's fewer cases. When the case is supposed to get reached at 2 o'clock, it actually gets reached somewhere near 2 o'clock. I know there's a concern, especially if I were Franks, I would have great concern that they're going to favor the large national corporation like General Motors in federal court, and I would share that, so I would probably have done the same thing that they did. But the fact is, from our own perspective, being able to control our schedule and being able to move a case from beginning to end, federal court certainly has significant advantages. And I've represented plaintiffs, and others have as well, where plaintiffs have done just fine in federal court. So to some extent, just like in state court, much of it depends on luck of the draw as to what judge you get, as opposed to whether I'm in state or federal court. There are judges that are more balanced in federal court than others, and just as there are judges more balanced in state court than others. So I don't know, I do understand where the thought comes from, because of the concern that the federal courts have more of a national interest in state. But the fact is, you could be successful and you could be screwed in either state or federal court, more dependent on who ends up being the judge that hears your case. The other benefit, by the way, to federal court, and I think I've said this before, is once a case is assigned to a judge in federal court, it stays with that judge. That judge will follow the entire case. And that's nice from the standpoint of not having to educate a new judge every time I come in on a motion or every time I've got to explain something. Again, it's nice if I get a judge that's good, potentially favorable to my side. It's not so good if I get a bad judge that doesn't like me from the time I get into there until he kicks me out of court. But at any rate, GM removes the case to federal court, as is their right. And then on January 5th, Frank seeks injunctive relief because they want GM to continue supplying parts and warranty administration for heavy-duty trucks because Frank's has been a GM franchisee since 1937. So it's like 50 years, 40-something years at the time. And in October '86, GM informed Frank's that from now on, Volvo was going to be doing the trucks, and that we don't need you anymore, Frank. Thanks for the last 45 years. So Frank was looking for some form of injunctive relief pending the outcome of the litigation. So what factors, I guess the first part, in the court, in looking at the request for injunctive relief, what is the test that the court needs to look at here? Because in this case, at least in part, they're saying that their review of the granted denial of the PI is limited to whether there has been an abuse of discretion in error of law or a clear mistake in the consideration of proof. That's under Roman numeral 2, which that sounds like this is going to be pretty hard to be able to overturn that judge's initial decision. They also talk about grant of injunctive relief is an extraordinary remedy. So what are the factors the court has to look at in deciding whether injunctive relief is appropriate or inappropriate? Go ahead.
Well, there's the 5-part test, but here specifically they were talking about them having to prove a likelihood of success on the merits and irreparable harm.
Right, those are the two big ones in this case, right? And once we get past no adequate remedy at law, that money damages will make them whole, this likelihood of success on the merits becomes the significant factor, and here the court says two significant factors. Show us a likelihood of success in the merits, and then tell us, and specifically, what the probability of irreparable harm, or sometimes we call it irreparable injury, is here. And they say we cannot sustain a PI where either or both of these prerequisites are absent. So they're putting an awful lot of weight on the likelihood of success and the irreparable harm or injury. They refer to it, by the way, here under A, the availability of adequate monetary damages negates any claim of irreparable injury, because obviously money would make it repairable. What do you think about, does Franks have an likelihood of success on the merits? Can GM just, after 45 years, just walk off like this and say, it's not good for our business, Frank, we don't care how it affects your business, we're out? Is it that simple?
I mean, there's no obligation, there's no rule of law that says they have to continue to service him. They're getting out of the business.
Regardless of how that might affect Frank, they have the right to do it. There's no contract that continues to require them to make them their provider of warranty service or supply the parts necessary to fix these trucks. You got nothing?
Maybe under promissory estoppel, if they had some huge investment in anticipation of the continued contract or something like that. I don't know.
But you can't continue to make them sell trucks they don't want to sell anymore. Right?
So,
Where is Frank's likelihood of success on the merits? Where is their irreparable injury? Franks asserts that it adduced proof that its overall business will suffer from the loss of its heavy-duty truck business. Probably true.
yeah.
Go ahead.
Well, I think that in the case they used the Morton case, or they looked at the Morton
Right.
case in comparing this case to that one, and in the Morton case, the job that he had was his only source of income, whereas in Frank's case, the heavy truck component only accounted for 26% of his income. And he was selling other heavy-duty trucks that were not produced by GM, so you don't really have irreparable harm.
And as in Morton, what is it that Frank says he's losing? Money, right?
Profit, yeah.
If he's losing money, well, that's a money damage claim. That doesn't suggest that he needs injunctive relief. That doesn't suggest he has an inadequate remedy at law. It suggests that his remedy is money damages. That's not irreparable. We'll just figure out how much money he's supposed to get, assuming he should win. And the fact that he can't show irreparable injury, that he can't show anything other than an economic injury. Says page 102, the bottom of that right-hand column, the availability of adequate monetary damages undercuts his claim of irreparable injury. In Morton, we noted that a purely economic injury compensable in money cannot satisfy the irreparable injury requirement. Although we are not sensitive to the financial distress suffered, we really don't care. Right? We're not insensitive, but we're not all that sensitive either. The loss alone can't constitute irreparable injury. Let's talk about the bond a little bit here, because this is one of the first cases that we really start to see how this bond is supposed to operate and can start to think a little bit about it. If the injunction is granted, if the court feels in its discretion that the moving party has sufficiently made a case that under the 5-part test that the injunction should be granted, at that point, Rule 65C is supposed to require the posting of a bond by the moving party. The bond, as it says in both B and then footnote 7, I think, talks a little more about it, and I'll talk about that in a minute. It says in B, it says that the district court failed to require Franks to post the bond, which is in direct conflict with Rule 65. It says, must require the successful applicant to post adequate security. Although the amount of the bond is left to the discretion of the court, the posting is much less discretionary. Only where there's no showing that the person will suffer damages as a result of the bond, no risk of monetary loss, would the failure of the district court to require a bond be okay. That bond is supposed to be there so that the non-moving party, if it's later determined that the injunction shouldn't have been granted, can look to that bond to make up its losses it suffered as a result of the injunction being issued. What this means for you guys is to start to think about that as another means of opposing the request for injunctive relief. Okay, if you're going to grant it, the harm to us is so high and so extensive, this is what we're looking at. So you need to be prepared to make a case for the damages you will suffer, which isn't difficult if you think about it, because one of the tests for injunctive relief is the balance of those harms. Now you need to start to think about putting those harms as well in monetary terms. Not only will we be harmed if you grant the injunctive relief, Judge, this is the likely amount of the harm. Therefore, we need that. If you grant it, we need a very high injunction bond. And the fact is, there will be times where then the party cannot post that type of injunction bond, and therefore the injunction doesn't get granted. So the bond amount, arguing for that bond, is another means of opposing the injunctive relief. If you look at note 7 that's on the page there, that if Franks does not prevail, GM will have been damaged. If you look at what this note says, it seems like this could be a very significant bond by any difference in the amount it receives from Franks' payment for the parts, plus the amount it pays to obtain the parts. B, by the amount it will expend to set up and administer this warranty service program that Franks wants the injunction to provide, as well as the claims it will have to pay to Franks for doing the work, because Volvo GM agreed to assume the responsibility. Franks argues that this is much like the orphan who has killed his parents complaining that he's an orphan, because he says that, well, GM's the one that made the choice to dismantle the program. GM's the one that did this without consulting Frank. But it doesn't really matter to the court, because they see it still, at the end of the day, these are costs GM will incur if we force GM to reinstitute the program that, for business reasons, they have no longer decided to do. If injunctive relief is granted, what GM is saying is we need a bond likely so high that Franks will never be able to post such a bond, meaning we win on that basis too. Here, the court is comfortable that Frank never met its affirmative burden of showing the irreparable injury or harm, and therefore the court was improper in granting the preliminary injunction. They also were wrong in not requiring Franks to post the required injunction bond. For both of those reasons, then they reverse and send it back to the district court to vacate the preliminary injunction. If there had been a bond, GM would now be able to look to the bond to recover some of its damages that it suffered as a result of what took place here. That's why we argue why we want a large bond, because it's another method of trying to deny the moving party what they're seeking. Questions on the case? Let's talk about Aoud versus Mobil Oil Corporation, because I want to know how you guys are going to try and prevent this from happening to you. And I hope you read it, because I think it's a very interesting case and very instructive for new lawyers. It also is written by Judge Selya from the First Circuit here, who oftentimes writes in very colorful language, as this was. Some would argue he's really kind of a jerk. But he writes an interesting decision, there's no doubt about that. How would you avoid doing what happened here? Because your client, you represented Celine. He has a couple of gas stations he wants to operate. And if you look at, I think it's footnote 2, right? It says, in his discussion with Schultz, plaintiff inflated the price paid Monahan, presumably to give him better leverage in dealing with Mobil. The next day, at Aoud's instigation, he and Monahan prepared an ersatz agreement inserting a price of $175, backdated it, and signed it, and he now admits the document was bogus. And that same document you attached to your complaint, right? Because I read that footnote, and I said, this is over, right? The rest of it is details, isn't it? Your client's a liar and a cheat. They tell me that in footnote 2 on the first page of the decision. Well, this is over. We're not going to do anything for a liar and a cheat, no matter how badly the case proceeds from there. Isn't that true? So how do you avoid something like this? Yeah, see, look at where that footnote originates. In late 1987, plaintiff sued Mobil, attaching to the complaint, or that was you attached it to the complaint, you're the lawyer. Attaching to the complaint what purported to be a copy of the Aoud Monahan purchase agreement. After discovery proved that the agreement was a fake, Mobil notified Monahan that because of his complicity in the fraud, it was terminating his franchise too. So, because I read that note and said, well, it's over. The rest of it is details. Aoud's not getting anything, and it really doesn't matter how badly things went for him here. Agreed? So now I need to know how you avoid your doing something like this. Because I don't think, I don't believe the lawyer was complicit in this, do you think? Because if you were the lawyer who prepared the agreement, now it's even worse, right? We'll assume it wasn't you. We'll assume you're just the litigator. And he brings you this document, tells you it's real, looks real. You decide it's a pretty powerful piece of evidence and you attach it to your complaint. And now he makes you look like a thief and a cheat too, no?
Or you do a verified complaint, or you attach an affidavit signed by him.
So, well, I could have him verify it, but at the end of the day, you're still the one proffering this phony document to the court as some type of evidence.
Well, but you can't accuse your client of being a liar when you're bringing it to you.
Should you have checked with Monahan?
If you had suspicion.
Well, is that what it is? If you don't have suspicion, it's okay? I mean, because, you know, if you think about it, I look at this, looks real. Well, he presents himself as real. By the way, before this, did you find his case sympathetic? He's operating one franchise, he's doing a really good job. All I want to do is have another one, make a little more money, and I can do it well, but they have this stupid ass rule that says, my rules, I can do what I want. Right? Right? That's what you're nodding your head vigorously about.
He shouldn't have signed with him if he knew that rule.
He knew that rule.
But you can't, Moynihan.
Tough luck.
Moynihan was complicit. He was part of this deal, so even if you had gone to him, he would have.
Well, he didn't, but he didn't have to inflate the price, didn't have to backdate that. I mean, I didn't know that. Did I, right?
Right, you didn't know any of it.
So no one feels that this rule is really kind of a stupid rule. If I can run one franchise and do a really good job, why do you have a stupid rule that I can't do another one at all, especially close by? I can run two, I can run a half a dozen. Or, because I could see where you would look at him and think, well, boy, Mobil Oil is really picking on a good guy they do business with for no good reason.
There's a reason. They want to promote competition so that the price stays lower so they sell more gas. Because that's the bottom line.
So that's what you're telling me, that the oil companies want to keep the price of gas low? That's the whole theory of this
No, they
idea?
want to get as much as they can from the people they're selling it to, but they also want them to get as little as possible so that they buy more Mobil gas and not Exxon gas. That's my point.
Okay,
So
well,
promotes
I hear you.
between those two Mobil gas stations.
So if they are too close, they may keep the price a little higher than otherwise, and
not sell as
Mobil
much
doesn't
Mobil
sell as
gas.
much gas.
Yeah.
He makes more profit because there's no direct competition. That wasn't in this case, though, right?
No, but you
No, okay. I mean, that's not a bad.
That might not be a stupid rule.
Well, it's not a bad argument, but I'm sitting here thinking you've got one guy who's doing really good business for you. Another one of your successful operators wants to sell to him. Until there's a problem, why act like there is? So I guess I'm just the only one that feels sympathetic towards him. John?
I think it's a stupid rule in this situation, but I also think the lawyer, common sense, would have told you that you're dealing with two franchisees of Mobil. You need to have Mobil. You need to have a representative of Mobil on somewhere in there too.
I thought he told you, though, and he did. And he told you that, well, he talked to the regional person, and they said this would be just fine. That's what he told you, right?
You could get something better than that.
Well, what better? Because he comes in and tells you, I need to get this deal done. Here's the P&S. Here's who I talked to. This is my track record of doing business with these folks. I guess I'm wondering what more you should have done to avoid. I mean, this is more than just an embarrassment, right? The court in footnote 2 is saying, you're a cheat. Right? You, the lawyer who attached it, aren't they? Go ahead.
I was just gonna say, like, if I was the attorney, I might want to get something in writing, like Mobil's policy as to like franchises, and look at the agreement. And if I see in there that Mobil doesn't like to see their franchisees own more than one station, then I'd be a little suspicious about the agreement he made with Monahan.
Well, but he could still make the agreement with Monahan. What he needs then at the next level is Mobil to sign off on it, right?
Yeah.
So it still doesn't necessarily mean anything wrong, because until Mobil disapproves and they say, no, we never talked, he never talked to any manager. I mean, he's giving you documents that look real. You thought they were sufficiently real that you attached them to the complaint. You go forward, and somewhere early on, or maybe even later on in discovery, the rug is pulled out from under you, and it's told, and you realize you have been, at best, innocently complicit in a fraud upon the court. Do we agree? You look like you've got doubts on that.
No, I agree with you, but I just don't like it. It obviously looked really bad on your part. Innocently complicit in a fraud. How do you?
That's the best it gets.
Yeah.
So how do you avoid that? Because I can see when this guy comes in with some money. He's got a story that could be plausible. He's got agreements that support what he said, that he was going to buy it, and there's numbers there, and tells you who he spoke to. Now says he needs an injunction. We know when you need an injunction, you're going to run off fairly quickly. mean, I've attached documents, and I attach documents to the complaint if I think they're really good and really will help. So I could do this. I could have seen this happening to me. I mean, I really don't know. Who would think that the document is backdated and signed? Who the hell does that? And who creates false documents? Clients? Huh? No. Is this something realistically you need to be worried about? And I think the reason I've included in here is that yes, you should. So how do we avoid it? Because this makes you look really bad.
There's one way here. When he swore, I guess, that he spoke to McFarland, that happened before the attorney filed his complaint, right?
Yep, plaintiff swears McFarland told him, this was plaintiff as Aoud, told him on June 19th that Mobile had approved the transaction.
So when he comes into you, he's saying to you, listen, they approved it. I guess you could at that point speak to McFarland as the attorney.
Okay, but McFarland works for Mobile.
Right, and he's going to say, I never said that.
Okay, but isn't that what someone's going to tell me after the fact anyway? Hey, did you discriminate against my guy because of his race, age, or handicap status? No. No, really, right? They're not going to say yes, right? Did you approve the sale? Because now we get a problem because Mobile's saying, no, I never said that. You got it in writing? No, I don't. Right? The other side is always going to disavow. That's why we have litigation. So I guess I'm wondering how much more you should have gotten, or any lawyer, because I don't know who the lawyer was at trial. Dave Berman, I know, does cases on appeal, and that's really all he does. So there was some other lawyer, was Aoud's lawyer at trial, who now gets to go nameless because it's not attached to this decision.
So what would you do?
Well, I'm asking you what you would do.
We do what you do. Whatever you tell us, that's all you do.
Well, I'll tell you one thing that this should underscore for you is your responsibility to check beyond that little circle, right? And I don't want to sound overly cynical, like you can never trust what your client says, but even with the best intentioned clients, they don't necessarily see the entire playing surface. They don't necessarily see exactly what unfolded. They see it as through the prism of their own eyes. And so we need to, trust, but verify, right? Because as it turns out, you got a bad actor for a client, right? Now, and that you don't always know, and you don't always know, you know this time. So if you represent them again, you get what you're entitled, you get what you've got coming. But on the first time through with someone like this, we got trouble because he's giving me documents, he's giving me stories, none of which now appear to be supported, and I'm knee deep in this case. I'm hip deep in the case, right? Because here's the problem that you've also done by attaching it. You haven't just done a disservice to you. You've really done a disservice to your client by not fleshing this out first. When I read footnote 2, I didn't have to read the rest of the case to say that he was losing, no matter how meritorious his case might have been, no matter how meritorious his argument on PI must have been. No one's going to do anything for a cheat and a liar, period. Go ahead.
So is there a way to get information from the opposition? So like in this case, suppose you wanted to know what the standard operating procedure was for a lease, because it says in there that Wade knew that Mobile requires documentation prior to him taking over the other franchise. So is there a way to get that information from the other side? That what's the standard operating procedure for this without making it look like you suspect?
Well, my guess is he's got a franchise agreement, right? And his franchise agreement will say that he's going to need Mobile's written approval for any other purchase of the franchise and transfer. And you would generally, even a layperson would understand that if it's a franchise like that, you don't get to purchase it without the franchisor approving any type of transfer. I mean, that really doesn't, right? So we all have an understanding of that, but it may say within those agreements that such approval can be granted on, case-by-case basis with the following information, or whatever it is. So you look at it, and to some extent, the agreement may support what he tells you. Is he knew that, said that, he talked to them, he got approval, and now they're disavowing it, and he relied on their promise. he entered into the P&S, and that he wants to argue some form of promissory estoppel or whatever at this point. I could call them and tip them off, but then they're going to go deeper undercover, and I'll be honest with you, and my own prejudice says that a company like Mobile, the big company, that now destroy the documents in evidence time, right? And that's, I know, again, that is cynical, but it also is unfortunately what sometimes happens when people have been tipped off to litigation, is you circle the wagons and you try to get rid of. Now, that, I don't think it's just my opinion. Under the law, it's not once litigation has been filed that you have an obligation to preserve documents. It's once you know that litigation is likely or litigation has been filed, you have an obligation to preserve the evidence under the modern standard. So if stuff is destroyed, if information is destroyed following my call to Mobile to try and get information, that will be harmful to them. In theory, that's fine. Okay, that's great. You always have a problem proving stuff has been destroyed because it no longer exists. And that's a very cumbersome process to try and get us to the point. And when you do get there, it's great. But it oftentimes means you've got to really go the extra yard to figure out where things were and what's been destroyed, and get people to admit, oh, we got rid of documents, or we purged the emails on this, we purged any records of the phone calls. But that's what I've got to try and show. And so I could call Mobile, but that's the other thing with a company like this. Who do I start with, and who do I speak to, and how do I even know I'm going to get anywhere near with the person to verify the story? And frankly, we're at odds on this case. The likelihood is I'm not going to get the truth from that side. I guess one thing you definitely should have done is talk to Monahan, right? It's Monahan, right? Yeah, Monahan was the other person to the P&S. You know, we talked about at times thinking that, well, at the minimum you got to talk to the client. Maybe you should have talked to him. Maybe you should ask, is this document accurate? I mean, at least to cover your back to some extent, right? Because as it turns out, I mean, look, the court is using language like complicity in the fraud, right? At any rate, let's look a little further with the case. You can't necessarily accept what your client's saying is true, even if it is, because you owe them the obligation to be able to support what they say. And so you've got to look further beyond the representations made. And here, I mean, this is bad luck for you, no doubt about it. Bad luck for me, because I would never have done this if I didn't think it was truthful and accurate. But we're in hip deep at this point. And this is bad. This reflects very poorly on us. And there will be clients like this out there. So I guess, what should we have done? More documents? More information? Talk to Monahan? Talk to other witnesses? Try to get verification from Mobile if you could? Something more than what happened here. Because attaching that complaint was just about the end of the line for you. Look at what the factors the court looks at, because then there's a whole, the thing is replete with errors that take place in the process here. And that's what we're supposed to be looking at this point as to how the process for injunction works. The court gave you, in Roman numeral 2, they talked about the factors that are used, and that's what we call the 5-part test. They list 4, but they don't list the no adequate remedy at law, which we always use. No adequate remedy at law, as we saw in the last case. Sometimes some courts will tie it to irreparable injury and the like. But what it means is that money damages won't make him whole. I don't know whether it will and won't here, but it doesn't matter, because he's gonna lose no matter what. As you see, Justice Selya likes to talk about Big Bad Wolf and all the rest of it. He then makes this horrible argument that Massachusetts law won't enjoin a trespass which is just pure crap. So you go from bad to worse. Now you're making absolutely unsupportable arguments in court. I assume this may have been made by the appellate attorney, jumping hip deep in as well. And he had been ousted from the Maple Avenue station. So when we talk about altering the status quo, a lot of times when we're seeking injunctive relief, we talk about seeking injunctive relief to do what's known as preserving the status quo, to allow the parties to remain in the last uncontested position during the pendency of the litigation. And so he says, you know, generally you should grant an injunction to maintain the status quo, but the last uncontested status here that preceded the pending controversy wasn't you operating 2 stations, it was you operating the one franchise you had been granted and Monahan operating the other. So there's no status quo argument that you can make. You just want to operate the 2 stations even though we never gave approval to do so. He wants to argue that they've waived this provision, but as you see in the language under waiver, there has to, in order to constitute a waiver, there must be clear and decisive and unequivocal conduct on the part of the authorized representative, and he simply couldn't offer that here. He says, whoa, wait a minute, I never even got a hearing. Appellant has raised a 3-part procedural challenge claiming that the order was issued, 1, without a hearing, 2, in the absence of contemporaneous findings, and 3, devoid of a bond stipulation. All of which are really good arguments. Certainly the First Circuit will consider each of those arguments because we generally do, as we saw last week, require a hearing if there's sharp factual disputes, and it would certainly seem to me that the credibility of these witnesses is an issue. And it says here, it uses the language, I don't know whether it cites the same case we saw last week, but it says here, as a general rule, where issues of fact are disputed, an evidentiary hearing is a highly desirable prelude, if not a necessary concomitant to the granting of injunctive relief. Then they go on to say, but it's not indispensable in cases where we're dealing with people like you. There were affidavits submitted, there were offers. The taking of evidence, as it says here, would offer little purpose. Again, the die is cast. The case is decided. No one's going to do anything if your client, and potentially you, is seen as a fraud and a cheat. And it doesn't matter how bad the process was here, because the process was incredibly bad. But he's still going to be out on his ear before this case ends. Now, they talk about a lot of nice language you can use in other cases about evidentiary hearings being preferred and all the rest of it. It doesn't matter. The problem with this guy is that they don't like him and they don't trust him and they don't care for his case. Case rises and falls with your first appearance in court, how your case is initially perceived. And here, not only did you do yourself a disservice, but the lawyer did the client a real disservice. You know, we need to challenge them. We need to make sure they understand about the veracity needed and the seriousness about going forward with the lawsuit. You know, I don't know whether he had that come to Jesus conversation or not, but I don't know whether, I would imagine you should have had some heart-to-heart about making sure that the information I get is serious and able to be verified, and that the fact is that we should be frank with each other so that we can be able to go forward at the greatest chance of success. And by the way, if you do all that, and he's still intent on cheating you and giving information that you can't verify as being lies, then that's going to happen. But sometimes you want to have a very serious dialogue at the outset of what's needed. And if you get a bad vibe, then you need to get even more information to make sure that your instincts are wrong. Because sometimes your instincts are exactly correct. More often than not, I've found that you're right, and you should learn to trust those. Here you've got a snake for a client, and you look pretty bad as well representing him. Just to look at the rest of it, he didn't get a hearing. The trial court was supposed to make those findings we talked about under Rule 52A. The court made no findings when issuing the preliminary injunction in Mobil's favor. Generally, if you don't make findings under Rule 52, no injunction should have issued. And here it even says, when we talk about those findings under Rule 52, the court doesn't have to necessarily write them out, and I've seen judges do that, that orally, at the conclusion of the preliminary injunction hearing, they will say, I grant the injunction for the following reasons. I find the following facts. And they'll just state them orally. Either they'll be recorded by the stenographer or the tape. And so as long as they're stated, the requirement isn't that they be in writing. The requirement is that findings of fact and conclusions of law be made, and be made on the record in some fashion. So they can be done orally. They weren't done orally, and they weren't done in writing. They weren't done at all here. It says that you can do it that way. Here, the court waited for some 2 months before delivering its findings. And they say that was simply too long to be acceptable. Because the case is actually on appeal at that point because of the question about the injunctive relief. So 2 months is too long. The court finds that unacceptable. So Frank's right. Or Frank's going to get some relief here? No, we still don't care, right? Even in that absence. And then the last part of it, he argues before us that he should have required Mobil to issue the bond for an appropriate amount to compensate Frank for compensate Sam Ayud in the event the injunction's wrongfully granted. Now, one big point, mistake he made, and they turn it back on him, and they'll turn it back on you if you let them. He never requested it at the district court. Okay, if you want something, you've got to ask the court for it. Having not requested it at the district court, he's got a real difficulty arguing now that the bond should have been granted, should have been posted. And then they go on to say the bond isn't a prerequisite to the validity of the PI, and that it was error, but they're saying, well, you're raising this untimely. If you look at Note 8, by the way, Mobil recognized sufficiently that that bond should have been posted, that after filing the brief in the appeals court, where I'm sure you pointed out that because of the failure of the bond, the preliminary injunction was ineffective, they went to the district court after the fact and asked the court to set a bond. The court did so. Again, another failure. They should have set that as well originally. They set $60,000 as the bond, and then Mobil, having no problem posting that, posted it. I hope, when you look at this case, what you think about is how you can avoid similar occurrences. And because there will be times where you will represent people that are untrustworthy and will potentially jam you up with some of the issues that they're engaged with. The problem, again, I think, comes back to doing that, or the solution is coming back to doing that very thorough investigation under Rule 11 and not accepting at face value what people tell you, but making sure that you've got enough information and that information also supports some of the other information you've got, right? I mean, there should have been letters, there should have been deposit checks, there should have been conversations with Monahan, there should have been more information available so that you don't get into a situation where it looks like you helped to try and perpetrate a fraud on the court. Because once that is uncovered, the case is over. And I've had cases like that where we were able to uncover fraud on behalf of either, usually their client in some fashion, and arguably the lawyer aware of it. And once you uncover that, it's clear that the case is over, and now the other lawyer, me, is going to play it up for everything I can. Because again, it starts with the premise that in order for the court to find in your way, find for you. They have to first believe that you should win. They have to believe that you have a just cause. Because no one's going to go out of their way to find for you at all if they think that your cause isn't just or that you aren't telling them the truth and in fact have the better reason why you should win. Here, I think he might have had a sympathetic case at the start, but by altering the evidence and concealing concealing the facts, he cost himself any potential chance of victory. In the process, he took you with him. So think about how we can protect against that. Happy Valentine's Day. Yeah?
Next week is a draft complaint. I mean, the injunction.
No, we're moving that to next week. We're moving that to the following week. So
you're
next
gonna
week.
pass out something for that? Like,
Say what?
Are you passing out a fact?
Oh, for the complaint?
Yeah.
Yes, but it won't be till the week of February 27th now.
Oh, okay.
So next week, section 7, we will do on Tuesday and Thursday. Thursday of that week, we will have a slightly shortened class because I have a trustees conference call. But we will do those cases that week. The draft complaint for injunctive relief will be on the Thursday, which I think is March 1st. Right? And I'll give you the fact pattern. I'll actually post it as well, so you don't have to come into the class and do it, you just have to do it. But I'll give it to you on Tuesday, the 27th. Okay? And I'll also post it online. So the draft complaint for injunctive relief, you get the facts and some information to look at for that, will be now on March 1st. Yes. Because then the midterm examination is the following. Okay? I'm sorry?
March 8th.
Yes. How many of you are thinking of taking the exam? Oh, really? Okay.
I don't.
Yep.
Does the exam harm? Is there a disadvantage in taking the exam?
No.
It doesn't harm you.
How would you, well, the exam would harm you if you got an F or a D. Is that the plan? No, I don't think so.
That's the plan.
Well, yes. Okay. Then let it just be clear. Well, so would sending the answers in if you don't do a good job, right? If you take the exam and you really aren't ready for it, but you should be if you've been coming to class and doing your reading and thinking about the issues, getting a D or F really isn't likely. It always does. I shouldn't say always does. The last time it did surprise me. Sometimes someone will come in and take the exam, and they really aren't ready for the exam. And I'm thinking, with the option you had, why would anyone take the exam if they weren't prepared for it when you could simply do all the questions sort of as a take-home and you can take all the time you want with it? So on occasion, I see a bad exam. But it's rare. Frankly, I'm stunned that so many take it. In the last 5 years when I've given people this option, there's usually less than a handful that take the exam. But your call. Huh?
Example ones.
Yeah, they should be downstairs. They're on reserve, and I think they're online as well. But if not, I know they're on reserve. And I'll check and make sure that last year's is on reserve, so you can take a look at that. Look at the Sim Pro too, because they're very similar fact patterns and issues that oftentimes overlap. Huh? Looks familiar.